for evaluating Texas Mock Trial Youth in Government. We're so grateful that you're here today. Each of the students that you will be evaluating have been preparing for this case since the beginning of the school year. Each of the teams and judges have qualified in their districts for the state conference. In order to be the best possible evaluator, it is important to remain unbiased and thoughtful throughout the day and be consistent and careful in your critiques and evaluations of students. Let's begin by going over what it looks like to be a good witness. A good witness has a credible portrayal of character, showed emotion appropriate to the role, showed an understanding of the facts within their affidavit, sounded spontaneous and not memorized, demonstrated proper courtroom decorum while they gave their testimony, was well prepared for cross-examination, and contributed to their team's case. An example of a good witness looks like this.
What happened on Monday night of Hell Week?
The Gammas forced the entire freshman pledge line to strip down to just our underwear. It was mortifying and people were crying and yelling. The guy Gammas then came out and started beating us on the backside with our frat paddles. It was so scary and intense it barely felt real. I got upset and I had an asthma attack.
Here the witnesses showed emotion, was easy to understand and hear, sounded like the answer came from their own memory rather than rote memorization, and contributed to their team's case, all of which are attributes of an accomplished witness. A poor witness might look like this.
What happened on Monday night of Hell Week?
The Gammas made everyone strip down to their underwear and were hitting us in the paddles. It was scary.
Here the witness showed very little emotion, sounded memorized, and did not have a credible portrayal of character. Therefore, this witness would be considered a poor witness. Attorneys have more responsibility in the courtroom than witnesses. They have to give opening and closing statements, as well as question witnesses and make objections. To start the case, attorneys recite an opening statement. This sets the stage for the rest of the case and introduces witnesses for that team. A good opening has provided a case overview that lets you know what this case is about and what they intend to prove by the time their case is over. A theme and theory for the case was provided, and they also mentioned key witnesses and what they are expected to testify to. The teams also provided a clear and concise description of the team's side of the case, stated a relief requested, which means they asked for charges to be brought and enforced. They discussed the burden of proof, and they did not use notes during the entire duration of their opening statement. A good opening statement might look like this.
Your Honor, ladies and gentlemen of the court, my name is Lynette Guidry, and today prosecution is here to show through facts and evidence that on February 2nd, 2015, Don Colson recklessly caused the death of his own daughter, Annabelle Colson. Annabelle was a loving, sweet, energetic little girl who loved playing with her sister and going to school. It wasn't until Annabelle became very sick when her whole life was flipped upside down. Don Colson was notified numerous times through Annabelle's pre-K teacher, Kate Riley, about her sickness, but yet he still refused to do so. That's why I ask you today, Your Honor, to please rule in our favor and find that Don Colson is guilty of second-degree manslaughter and injury to a child. Thank you for your time.
The attorney sets the mood for the courtroom and begins to present the case from their side of the argument and asks for a verdict in their favor. They bring up the burden of proof and talk about key witnesses. This is an example of a poor opening statement.
Okay. Your Honor, my name is Lynette Guidry, and today prosecution is here to show that Don Colson is guilty of second-degree manslaughter and injury to a child because he was notified numerous times through Annabelle's teacher, but he still didn't want to do anything about it. And because of this, his daughter's dead. So please rule in our favor and find that Don Colson is guilty of second-degree manslaughter and injury to a child. Thank you.
In addition to opening, at the end of the trial, attorneys must give closing remarks to sum up the information and evidence brought up during the trial. A good closing consists of a theme or theory continued in the closing statement. They summarize the evidence. They emphasize supporting points of their own case and damaged points of the opponent's case. They concentrated on the important rather than the trivial. They discussed the burden of proof, showed how they proved it. They are overall persuasive in their argument, and they have minimal reliance on notes. Here is an example of a good closing statement.
Your Honor, we are here today because two people are dead. Mother and son, Millie and Tommy Sanders, as evidenced by Dr. Joshua Sapp. The prosecution has met its burden of proof, clearly establishing that Greg Shears is guilty of capital murder beyond a reasonable doubt. Let's revisit the night of July 4, 2013. When she returned home, Greg Shears witnessed Millie and her ex-boyfriend, Mr. Barber, kissing. Enraged, Greg Shears engaged in a heated argument with Millie. Tommy, following his mother's instructions whenever they fought, to go to his room and close the door. When Tommy heard his mother begging for her life, he rushed out of his room to save her. Unfortunately, Tommy rushed out only to find his mother beaten with a rubber hammer. Despite his efforts to save his mother, he was stabbed with a knife. Both causes of death were established by Dr. Joshua Sapp, who meticulously examined both deceased bodies. The evidence has shown that Mr. Barber witnessed the event over the phone as he heard the horrifying screams of his beloved friends, Millie and Tommy, being brutally murdered by the defendant just before he called 911. When the police arrived on the scene, they discovered the bloody handprints of Greg Shears on the wall. The defendant's fingerprints were also discovered on the knife that the weapon slayed Tommy Sanders, which was discovered by Detective Emily Hodges. Detective Hodges stated that in her expert opinion, the murder of Millie had been intentional, explaining why the hammer had been wiped. Tommy walked in, surprised Greg Shears, and who then killed Tommy to cover up his guilt. In a panic, he fled, not spending any time to wipe the knife or even shut the door. The defendant has attempted to cover his horrific acts by claiming he was passed out as a reaction to alcohol and codeine. We believe that, in fact, he plotted to use his allergic reaction to this drug to his advantage, timing his plan perfectly. He knew exactly how long it would take for the drug to ease off of his body. 4 hours. It had happened before. How convenient it was the defendant woke up exactly 3 minutes after the 911 phone call, just enough time to check out the bodies and rush over to his neighbor's house. In addition, Brianna Auteen's calculations are not reliable since she couldn't know whether the defendant was really a heavy drinker or not. The defendant intentionally murdered Millie and recklessly caused the death of Tommy. Motive, opportunity, and means have all been established by the prosecution's case beyond a reasonable doubt. The prosecutions ask you that you find the defendant guilty of capital murder. Thank you.
The closing keeps with the theme made by the attorney and summarized the evidence well. The attorney focused on important arguments and was persuasive and clear. The burden of proof was discussed, and the attorney made sure to ask for the ruling they wanted on the case. A poor closing might sound like this.
Today we have heard from 3 different witnesses that have provided information toward our cases. We know that Greg Shears is guilty of murder because he had the motive and opportunity to do so, which was proven through the witnesses we called. He had no prescription for his medication and had no record of taking it and no toxin screening to try and prove that he did or did not take it, so we cannot trust his alibi. Please find Greg Shears guilty.
A good direct examination has developed a clear picture of how a witness fits into the facts to be proven, avoided asking leading questions, asked questions that are concise and understandable, handled objections appropriately, effectively, and did not overuse them as a disruption tactic, responded to opposing counsel's objections with proper exceptions or with sound reason, developed the direct examination through the use of conversational language, and handled physical evidence appropriately and effectively, and did not sound scripted or rehearsed. An example of a good direct examination looks like this.
Can you introduce yourself to the court?
My name is Riley Smith.
How are you connected to this case?
I'm the sister of the deceased.
Where were you during the murder?
Objection, Your Honor. Calling this a murder is premature.
May I respond?
Yes.
This crime is still a murder if it is committed in hot or cold blood and should still be a fair characterization to call it a murder.
Overruled.
Where were you during the murder?
I was upstairs with my little brother.
The attorney begins their questioning by establishing a foundation for the witness, painting a clear picture of how this witness plays into the role of the story, asking short and clear and easy to understand questions. The attorney should let the light shine on the witness for this section, instead of themselves, The attorney responds well to the objection with sound logic and makes sure to ask the question they need answered again. An example of a poor direct might look like this.
Where were you?
Objection, Your Honor, this is an ambiguous question.
Sustained. Please rephrase, counsel.
Where were you during the murder?
Objection, Your Honor, this is a lack of foundation. The court has no idea who this witness is, according to the record, or how they are they connected to this case.
Sustained.
What is your name and how are you connected to the case?
Objection, Your Honor, compound question.
Sustained.
In this example, the attorney asked unclear questions and did not lay a proper foundation for them either. They did not respond well to opposing counsel's objections and did not rephrase questions well. Every question was objectionable, and the counsel did a poor job of focusing their attention on their witness. On the flip side of the coin is cross-examination, when an attorney questions a witness from the opposing team. A good cross-examination includes only leading questions, a story developed through the attorney rather than the witness, and questions that are short and to the point. They are questions that properly impeached or discredited the witness or case through the witness, and objections that are handled appropriately and effectively without overuse to try to disrupt the flow of the trial. They used various techniques as necessary to handle non-responsive witnesses, and they used variations in vocal tempo, tone, volume, and pitch when cross-examining. An example of a good cross-examination looks like this.
You have a monthly parking contract at the Garrett Garage, correct?
That's true.
The Garrett Garage is located at the corner of Randolph and Dearborn, right?
Right.
Your office is located at 48 South Dearborn.
Yes.
And to get to your office from the garage, you must cross Randolph, correct?
That's true.
Then you must cross Washington, right?
Yeah.
Then you must cross Madison.
Yes.
The victim's body was found near the corner of Madison and Washington, correct?
That's true.
A good cross-examination should sound as though the attorney is the one testifying. The question should be short, plain, and leading. The attorney makes the examination appear to be a series of damaging statements to which the witness must agree and therefore admit the truth. A good cross-examination also impeaches or discredits a witness' direct testimony, effectively scoring points for the opposing side. An example of a poor cross-examination looks something like this.
You're a thief, yes or no?
What?
Have you ever stolen, yes or no?
No.
You are a thief, you just lied, right?
No.
But you lie a lot because you said Greg Shears was a mean guy.
What?
What do you know as a single mother who likes Greg?
What are you talking about?
You also like beer.
I guess.
You think it's good for the soul?
Um,
Does beer make you lie less? Maybe you should have some beer.
This is an example of a poor cross-examination by an attorney. The lawyer fails to prove a point or get any important or useful information out of the witness. They also ask open-ended questions that allow the witness to control the cross-examination. A strong cross-examination should only have leading questions. The attorney posing the questions has poor control and employed no tactics to elicit responses or responses favorable to their case. Next up is trial judges. A good judge has a sound understanding of calling the court to order, communicating rules, swearing in witnesses, knowledge of the trial procedure. They display knowledge of evidence rules. They handle objections well. They have good demeanor and professionalism in the courtroom. Their interactions with trial participants are smooth. They have quick and sound decision-making ability, and they maintain courtroom decorum at all times. An example of a good judge looks like this.
And how did you feel about what Mr. O'Connor did, Mrs. Jones?
Objection, Your Honor. This question calls for the opinion of a lay witness.
Your Honor, may I respond?
Yes, you may.
This witness is simply telling within his rational perception about how she felt about a certain situation and action, and this information does not go to the truth of the matter asserted.
Your Honor, may I respond?
No. Thank you, counsel, but I still believe this calls for the opinion of the lay witness. Sustained.
In this instance, the judge remained calm, collected, and professional throughout the exchange of responses and objections, and also kept the exchange between the opposing counsels short. They remained in control, came to a decision quickly, and stuck to it. An example of a poor judge might look like this.
And how did you feel about what Mr. O'Connor did, Mrs. Jones?
Objection, Your Honor. This question calls for the opinion of a lay witness.
Your Honor, may I respond?
Sure.
This witness is simply telling the court how she felt about a certain situation and action, and this information does not go to the truth of the matter asserted.
Oh, okay. Thanks.
Your Honor, may I respond?
Sure.
This question does call for information pertaining to the truth of the matter asserted and is still asking for the opinion of a witness that is not allowed to give it.
Your Honor, may I respond?
Nah. Overruled.
This judge had poor control over the direction of the courtroom and let the attorneys argue with each other rather than the bench, and they did so for too long. The judge did not seem to have a good understanding of the law or to be comfortable and confident in making a ruling. The judge was lacking in a strong courtroom demeanor and had poor professionalism. As an evaluator, place yourselves in the shoes of a juror as you evaluate the performance of each of the participants. However, be careful not to judge the performances by things you felt should have been included. For example, another witness or another piece of evidence, since the participants are not allowed to go outside of the provided affidavits and case materials of this mock trial. You will be provided with an evaluator's rubric, where specific items will be itemized for you. This presentation has attempted to cover each of those points so that you will have an idea of what you are looking for. Winning the verdict only accounts for one additional point being given to a team. You will be asked to evaluate each participant's performance. Did the participants act professionally? Were they believable? Did you feel they did an overall good job? If you want to, at the conclusion of the trial, you may provide the students with verbal feedback on what they did well and what they can improve on. Your comments are invaluable in this learning experience and are appreciated by every student as well as their advisors. Thank you once again for your willingness to participate in this mock trial event.
What's wrong with being confident? What's wrong with being, what's wrong?